Hello, my name's Kedge and I'm McKenzie Friend, and I'm going to do this blog today about how to beat barristers in family court, particularly at final hearings. I love going to final hearings as a McKenzie Friend with my client, and on the other side is a barrister and their client no doubt paying hundreds and hundreds, if not thousands of pounds for the privilege of legal representation. And what I say to my client is sit back, relax and just enjoy the theatre, because that's all it is. Because what happens is you see the barristers either standing or sitting giving their performance, and they would wave their arms about, they would talk in meaningful tones, sometimes they'll even slow the conversation down, thinking that somehow by talking slower it makes their point more meaningful. But of course it doesn't. They're just talking slower and they're putting on a performance under the instructions of their client. And actually watching barristers quite often reminds me of the orchestra on the decks of the Titanic. They're playing as best they can under the conditions, knowing that they're going to be going down with the ship. So how do I sit there with my client feeling confident about our position when we watch the barrister give a performance? Well, the answer is very simple. Is that right from the very beginning, I often have quite difficult conversations with my client, not about what they want, but try and look at things from the perspective of the court and from the Cafcass, on putting the interest of the children as being absolutely paramount and actually seeing things through the eyes of a child, and what's based on someone's needs or fairness, whether it's to do with child arrangements or financial settlements. And what I will do as early as I can is trying to move my client's position to a centre ground, a one which is reasonable, balanced and proportionate, because at the end of the day that's what a court is going to do. They're going to give a judgment based on what is reasonable, balanced and proportionate. And the closer I can get my client to that centre ground, the easier our job is. And once we're there, basically what we do is just send that proposal to the other side for settlement, and they have two options. The other side is usually legally represented. They can either compromise around the middle ground, or they can reject it and come at us with something far different. And more often than not, they come at things which are really at quite extreme levels. There's kind of a lot of conflict and acrimony thrown into that. And it doesn't surprise me, because they're legally represented, and one can imagine that raising conflict when it comes to solicitors pays their bills. But we don't respond. So I just say to my clients, that's fine, we'll just go to our final hearing based on what we believe is our reasonable position. So what happens is that probably a day before the final hearing, who knows, even on the train going down, the barrister will have a look at the bundle for the first time, and then they'll realise that the solicitor of their client has actually set them up in a position which is not reasonable, which they're not likely to get, and where their own clients have got false expectations, unrealistic expectations. And so when it comes to the day of the final hearing, it's easy for me. I just sit there with the client and say, well, we presented our position, which we believe is very fair and reasonable, whilst at the same time the poor barrister on the other side, under instructions of their client, have to now give this performance to try and sell something which isn't going to happen. The fact is that no barrister in the world can take a proposal that is fundamentally unrealistic and turn it into something that is reasonable. It just can't be done. The courts are wildly experienced, very experienced, judges and the magistrates, and they'll know that what's being presented is unreasonable. They'll look at our proposal and say, that's far more within the middle ground. Now, we might not get everything we want, a few tweaks here and there, but we'll be sitting within what I call plus or minus 10% within the right area. I always know when the barrister's thrown in a towel once they give their performance, and they'll explain to you how I know that. And you may see it in your cases. Barristers, knowing that they are trying to represent an unreasonable position, will say this to the magistrates or the judge. My client has instructed me to say this. And that's just code to the courts, that's code to the magistrates and the judges to say, I haven't told my client to say this, it's been passed to me in the bundle, but I am clearly under professional instruction to actually present the wishes of my client, although we all know that what I'm saying is entirely unreasonable. And the way they package that up is when they say to the courts, I have been instructed to say this. It's a polite way to say, don't shoot me. As soon as I hear that, I have a little chuckle, because I know then that our case is sitting where we need to be. And I just reassure my client, and quite often my client doesn't even have to speak. And that's how you beat barristers in family court.